Good morning. We are on the record in Brooks versus Brooks on the pending custody modification and parenting time issues. Before we reach the parenting schedule, I understand there is a preliminary motion from the respondent regarding petitioner's counsel. Mr. Ellis, you may proceed.
Thank you, Your Honor. Before the court reaches custody, parenting time, or any issue involving the child, the respondent asks the court to address a threshold matter of fairness. Petitioner's counsel previously represented my client in a criminal matter. That representation may have been limited in duration, but it was representation nonetheless. And once that relationship existed, duties attached.
Ms. Mercer, you'll have a full opportunity to respond. All right. I've reviewed the motion and the written response.
Those duties do not disappear simply because years have passed. They do not disappear because the present case carries a family caption instead of a criminal one. They do not disappear because opposing counsel now prefers to describe the earlier matter as minor. The question is not whether the old case was dramatic. The question is whether my client should be required to litigate custody against an attorney who once owed him loyalty and confidentiality. Our position is no. Former client protection means something precisely in cases like this. Family court does not operate in a vacuum. It does not evaluate schedules alone. It evaluates judgment, stability, credibility, decision-making, parental fitness. And when an attorney has had prior access to personal information that could bear on how a parent is perceived, the integrity of the proceeding is at risk.
Mr. Ellis, let me begin here. When did your client first realize that Ms. Mercer was the same attorney involved in the earlier criminal matter? And when did he first communicate that concern to you? I want to be clear on the timing, because this family case did not begin last week.
My client recognized Ms. Mercer's name from the beginning. What became clearer as the case progressed was the degree to which issues overlapping with credibility and judgment were moving closer to the center of the dispute. That is when the ethical concern sharpened. That is not tactical invention. That is responsible recognition of a conflict as its consequences become clearer.
So your position is that the conflict existed from the moment she appeared in this case, but the motion was not filed until after discovery had moved forward. Is that accurate? Delay alone does not erase conflict. The duty to protect former client confidences does not expire because a party failed to race into court soon enough for the other side's liking. Ms. Mercer, I'll hear from you.
Thank you, Your Honor. I do not dispute that years ago I had a brief, limited appearance involving Mr. Brooks in a separate criminal matter. What I dispute is the respondent's attempt to turn that short appearance into something much broader than it was. I was not Mr. Brooks's long-term criminal defense attorney. I was not retained for an extended representation. I did not build a trial strategy for him. I did not continue as counsel through the life of that case. This was a narrow, time-limited appearance on an older matter that closed years ago. The motion before the court asks for the most drastic remedy available, but it does so on a highly inflated version of what that prior contact actually was. The current family case is about present-day parenting. It is about school week stability. It is about repeated exchange issues. It is about childcare timing. It is about missed reimbursements and communication failures between the parties. The respondent wants the court to believe this custody hearing somehow turns on an old criminal file. It does not.
Let me ask you this directly. Are you disputing that you had a prior attorney-client relationship with Mr. Brooks in any form?
No, Your Honor. I'm disputing the scope the respondent is now assigning to it.
I understand your position on scope, but even limited representation can create duties. So help me with the distinction you want this court to draw. Was that prior matter brief? Was it limited? Was it connected in any direct way to the custody issues before me today?
It was brief. It was limited. And it is not the basis of the custody dispute before the court today. The evidence in this case is current. The timeline is current. The concerns before this court are current. And that matters, Because if this were truly a disabling conflict, it would have been raised when I first appeared in this family matter. It was not. If it were truly so serious that I could not ethically remain in the case, the respondent would have brought that to the court immediately. He did not. He waited. He waited through the initial stages of the case. He waited through the early conferences. He waited while custody issues were framed. He waited while the parties exchanged information. And then, only after discovery began to narrow the facts, the conflict suddenly became urgent. Your Honor, that timing is not incidental. By the time this motion was filed, the record had started to harden. Daycare logs had been requested. Exchange records had been organized. Reimbursement issues had been reduced to numbers instead of accusations. Communication between the parties had been arranged by date and sequence. The picture becoming clearer is what changed here. Not my role, not my identity, not the existence of an old matter. What changed is that the respondent no longer liked the direction of the current record. And instead of answering the record, he is trying to remove the attorney presenting it.
Opposing counsel wants the timing to do all the work here. But delay alone does not erase conflict. The issue remains the same. My client once consulted with and received legal representation from this attorney in a matter involving personal conduct and sensitive information. He spoke to her in confidence. He understood she was acting on his behalf. That relationship matters, and the court should not reduce it to a scheduling footnote simply because the prior representation was brief. Brief representation is still representation. A short meeting can still involve confidential communications. A limited appearance can still create trust. And once that trust exists, the former client is entitled to protection. The court asked what prejudice remains if the old matter is walled off. Respectfully, Your Honor, the problem is not solved so neatly. Knowledge cannot be unseen. Information once learned does not vanish because a court instructs counsel not to mention it. The former client still has to sit across from that attorney and wonder whether questions, strategies, pauses, and lines of attack have been shaped by what she learned while she stood beside him. The rules governing conflicts are designed to prevent that very situation. They do not require us to wait for a visible misuse before acting. If courts required proof of direct misuse every time, the protection would already have failed by the time relief was granted. The law is prophylactic for a reason. It protects against the unfair position itself.
All right. Mr. Ellis, here is the question I'm struggling with. If the court were to prohibit any reference to the prior criminal matter, any use of records from that matter, and any argument derived from that matter, why would disqualification still be required? I understand the argument that knowledge cannot be unseen, but I need something more precise from you than general discomfort. What specific prejudice do you believe remains if the old matter is fully walled off? And I'm not asking for broad ethical language. I'm asking how this hearing on current custody and parenting time becomes unfair if counsel is barred from using anything tied to that earlier file.
Opposing counsel says she does not need the old matter. That statement, even if made in good faith, does not eliminate the conflict. It only highlights the practical point that another attorney could handle the case without this problem. And that is why disqualification remains the cleanest remedy. We are not accusing Ms. Mercer of bad faith. We are not accusing her of acting maliciously. We are saying that the situation is structurally improper. My client should not have to gamble on whether a former attorney can perfectly compartmentalize old confidential information while litigating against him in a custody dispute. He should not have to rely on assurances. He is entitled to a proceeding that is free from that shadow altogether.
Ms. Mercer, same question to you. If I deny the motion, can this case proceed on present-day evidence alone? School schedules, exchange history, daycare records, reimbursement disputes, communication between the parties, nothing from the older matter. Can you proceed that way?
Yes, Your Honor, absolutely yes. I do not need the older matter to litigate this custody dispute. I do not need it to address parenting time consistency. I do not need it to address missed exchanges. I do not need it to address schedule instability. I do not need it to address reimbursement failures. I do not need it to address the respondent's own present-day communications with my client. The current record is sufficient on its own. That is why disqualification is unnecessary. Courts should be careful with former client confidentiality. But caution does not automatically mean removal. Not every prior contact justifies disqualification. Not every old file follows an attorney forever into every later courtroom. The law requires precision here. It requires actual analysis of scope, timing, gekken, and relationship between the old matter and the current one. On all three of those factors, the respondent's motion is weak. Scope was limited, time was distant, and the present family case stands on recent conduct and current evidence. I would also note, Your Honor, that the respondent has shown no actual misuse. None. No question I have asked in this case draws from that old matter. No filing I have made relies on that old matter. No exhibit I intend to use comes from that old matter. No argument I have advanced depends on it. If the court wishes to enter a protective limitation, I will abide by it completely. I have no objection to a clear order stating that the older matter is off limits. That would protect the process. It would protect any legitimate confidentiality concern. And it would allow the case to be decided on what matters most, which is the child's present routine and present best interests.
Mr. Ellis, one more point. Why was this not raised at the beginning of the case? If the concern was truly disabling, I would have expected a motion much earlier. Instead, what I have is a motion filed after the record appears to have tightened. I'm not making a finding on motive at this stage. I'm telling you that timing matters when the court is asked to impose a drastic remedy. Counsel disqualification is not a small housekeeping order. It disrupts the case. It imposes cost. It creates delay. And in a local family docket, replacing counsel on short notice is not always simple. That matters too.
I understand that disqualification affects the course of the case, but inconvenience to the petitioner cannot override my client's right to confidentiality. Ethical rules often impose inconvenience. That is not a reason to ignore them. To the extent opposing counsel suggests this motion appeared only because discovery became uncomfortable, that is speculation about motive, not an answer to conflict. The court need not resolve motive to resolve this motion. The facts establishing the prior relationship are enough. My client had a reasonable expectation of confidentiality with Ms. Mercer. The present case places her in direct adversity to him, and there is meaningful overlap in the broad human subject matter, even if the case numbers are different. That is the concern, not theater, not delay for delay's sake, not gamesmanship, protection. If the court denies the motion, my client proceeds under a cloud he should never have to litigate under. Every question becomes suspect. Every strategic choice becomes uncertain, and the fairness of the process is diminished, even if no one can point to a single sentence and say, "There, that was the misuse." That is why former client conflict rules are broader than actual proof of bad conduct. They preserve trust in the system itself. So, yes, Your Honor, we appreciate the possibility of a narrower order. But our position remains that the narrower order does not fully solve the problem. The former attorney would still be in the case. The former client would still face her. The appearance of unfairness would still remain. For those reasons, we ask the court to grant the motion and remove counsel from further participation in this matter.
Your Honor, removing counsel this late is not a technical adjustment. It would force my client to start over in the middle of an active custody dispute. It would increase cost. It would delay resolution, and delay in family court is never neutral. Delay changes leverage. Delay changes schedules. Delay changes the real life of the child while the adults keep arguing. So when the respondent asks for disqualification, he is not asking for a tidy ethical correction. He is asking for a tactical reset of the entire case. That is why the timing matters. And that is why the court should be careful not to let the language of ethics become a shortcut around the actual merits. For those reasons, we ask that the motion be denied. If the court believes additional safeguards are appropriate, I will comply with them fully. But there is no basis on this record to remove me from the case.
I'm prepared to rule. The court takes former client confidentiality seriously. A prior representation, even a limited one, can create continuing duties. The passage of time does not erase privilege, and this court is not going to allow old confidential history to become a back door into a present custody dispute. At the same time, disqualification is a severe remedy. On the record before me, I do not find that removal of counsel is required at this stage. There has been no showing that Ms. Mercer has used confidential information from the old matter in this family case. There has been no showing that the present custody dispute cannot be litigated on current evidence alone. Accordingly, the motion to disqualify counsel is denied. However, the denial is not without limits. Ms. Mercer is barred from using, referencing, implying, or drawing from any material connected to the prior criminal matter involving Mr. Brooks. That includes records, notes, recommendations, screening information, or any derivative argument rooted in that matter. The custody hearing will proceed on present-day issues only. If respondent later demonstrates that the earlier matter has been used directly or indirectly in violation of this ruling, the court will revisit the issue immediately. Let me be plain. This court will protect confidential history, but it will not remove counsel on speculation alone when a narrower remedy will protect the integrity of the proceeding. All right. With that issue resolved, we will now return to the custody modification and parenting time matters. Mr. Ellis, you may proceed on the merits.